Hey there, welcome back to yet another episode in the journey of demystifying the Patent Act. In the last episode, we discussed various provisions and associated timelines for requesting the Patent Office to examine our application. So, as applicant, we played our part to the perfection in the pre-application phase of our invention. Now it's the time for the folks at the Patent Office, the controller and the examiner to play their part. In this video, we will visit the desks of the controller and the examiners to observe various procedural steps and the associated timelines as our application goes through the examination process. Let's get started. As the controller receives RFE and the application is already published, controller refers the application to an examiner and requests the examiner to prepare a report under section 12 and 13. To know more about the examination process under section 12 and 13, let's move over to the examiner's desk. As the examiner prepares a report under section 12, the examiner checks if the application, all the forms, the complete specification, and any other document are in compliance with the requirement of the Act. The examiner also checks if there is a lawful ground of objection to the grant of a patent. More importantly, the examiner conducts a search for identifying published documents that could anticipate the invention. Finally, the examiner may evaluate any other matter relevant to the application. Once the process is done, the examiner sends the report back to the controller. But before we move on to the controller's desk, let's spend some more time here to understand what all documents are considered by the examiner during the investigation. So as per section 13, there are two types of documents which are considered by the examiner. One, Indian patent applications, which are published before the filing date or which are published on or after the filing date. And second, all other documents which are published before the filing date. Now this could be patent or non-patent references across the world. Let's get into the specific of section 13. Now 13.1a talks about invention being anticipated by publication of Indian applications which are published before the filing date. Section 13.1b talks about invention being claimed in the claims of Indian patent applications which are published on or after the filing date of our application. Another set of documents are all other documents which are published before the filing date of our complete specification. Section 13 also provides a guideline that states that in case specification gets amended before the grant of the patent, then the amended specification would be examined again as the original application was examined. Interestingly, the section 13 ends with a disclaimer which says that no warranty of the validity of the claims will be given, or the patent office or the central government or the officers will not incur any liability because of the perceived validity of the claims. Interesting, isn't it? Now with this, the report is done. And it's time for the examiner to send the report to the controller. Examiner is required to prepare the report within 1 month, but not later than 3 months. So between 1 and 3 months, the examiner should be able to provide the report to the controller. Now at this stage, we are back to the controller's desk. So under section 14, controller is required to consider the report and generate an FER which will only include gist of the objection raised by the examiner. Now as per the timeline, the controller is required to review the report within 1 month and dispose of the application in 1 month from the review date. Now look at the chart. Who is receiving the examination report? It is received by the applicant and not by the person interested. Even if person interested would have filed the request for examination. Anyway, just an interesting fact. Now the applicant is back into the picture and the applicant has to go over the first examination report, understand the objection, prepare the response and prepare the argument or make amendments so as to overcome the objection raised by the controller. As per section 21, the applicant is required to respond to the FER within 6 months from the receipt of the FER. You can further extend the time by additional 3 months by filing Form 4. Now at this stage, the applicant can request for a hearing, or controller can schedule a hearing for providing an opportunity to the applicant to explain his stand or to discuss amendments that can overcome the objection raised by the controller. Once the hearing is conducted, a written statement needs to be submitted by the applicant to the controller, ideally within 15 days of the hearing date. At this stage, controller has obtained the report from the examiner and response from the applicant. Now the controller has to make a judgment call whether to allow the application or to reject the application. Now there could be a case where the claims in the application may not be satisfying the requirement of section 7.1 and section 10.5 unity of the invention. So the controller may ask the applicant to choose a set of claim that he would want to be in this application, and the removed or other set of claims can be filed as a divisional application. Interestingly, the divisional application and the previous application should have the same complete specification, substantially the same complete specification, but the claims have to be different. If that is not followed, then the controller may require you to amend the specification of the original application or the divisional application before the controller goes ahead and issues a decision. Now, the other judgment that the controller needs to undertake is with respect to the references which were identified by the examiner. Let's take the first case where the invention was anticipated by the publication of either the Indian application or any other documents before the filing date of the invention. In such case, the controller may refuse to grant the application, unless of course the applicant is able to prove that the priority date of my claim is before the publication date of the documents which were cited by the examiner. Concept of priority date, wherein if my priority date is before the publication date of other documents, then those documents cannot be considered as a relevant prior art for me. Or if that is not possible to prove, the applicant can of course amend the specification, more importantly claims, so as to bring out the differences from the cited references. Now taking another scenario where the invention was claimed in the claims of specification which were published on or after my filing date. And there could be another case where it was claimed in the specification which were published before my filing date. In those cases, the controller may direct that a reference to other specification be inserted by way of notice of public in your specification, right above the claims. Unless, of course, the applicant is able to prove that the priority date of my claims is before the priority date of other claims. Concept of priority again. Or, of course, I amend my specification, more specifically my claims, to get out a difference. Otherwise, a reference to that application has to be inserted. Here I have provided a format of how the reference needs to be inserted. During examination phase, the controller also looks into a scenario where your invention cannot be practiced by someone else or worked by someone else without infringing claims of another patent. Now, in such scenario, the controller may want you to insert a reference to that other patent in your complete specification. Unless, of course, you can prove that the validity of such claims of that specification can be questioned, or you amend your specification so as to make a difference. Now consider a scenario where such a reference was inserted, and now we are in a situation where that particular patent is revoked or ceased to exist. In such case, the controller may delete the reference. There could be another scenario where the other patent got amended and the claims are removed from there. In such cases also, the reference inserted in your application can be removed by the controller. Finally, before a proceeding in front of a controller or a court, it was proved that those claims don't get infringed by the working of your invention. In such cases also, the reference inserted in your application will be removed. So this brings us to a stage where controller has views from all the sides and is ready to issue his decision. So as per section 15, controller issues a decision whether to grant a patent or whether to reject a patent. This of course can be appealed by the applicant. This is all about the examination process. We have specific timelines for all the steps in between. Overall, there is no specific timelines as such. What about the expedited examination process? So the expedited examination process also follows the same process in principle, but the timelines of the steps in between are reduced. The idea is to grant the application at the earliest. There have been cases where applications have been granted within a period of 9 months. That's super fast as compared to what you get in the normal examination process. So this brings us to the end of this session. In the next video, we will spend some time going over few use cases, publications, or working on inventions, which may not be considered as anticipating the inventions. So I'll see you in the next video. Till then, be good and take care.